Good morning, everyone. I hope that you can hear me. This is my first time using a Zoom webinar, so this will be a learning process for me, and I hope you'll be patient if I have any screw-ups. If you haven't used Zoom before, there is should be a tab on your screen that gives you the option to ask questions. I will hold those until the end of the presentation because I don't think I'm coordinated enough to be able to do the presentation and review the questions at the same time, but feel free to ask any questions using that Q&A tab, and we'll try to get to as many as we can when we reach the end of the presentation. I see a couple of questions popping up about how to mute. I can't see or hear any of you. I think we've got those settings turned off. So you should be good on that end, but if you have any issues or can't hear me, let me know. Stay off that screen. Okay. So our topic today is the mandatory paid sick leave and FMLA expansions that have recently been enacted through federal legislation and how they're impacting specifically the construction industry, but also many other employers. The two key issues are the mandatory sick leave that applies to many employers who wouldn't otherwise have to pay sick leave, and a limited in scope expansion of FMLA. These go into effect tomorrow, that's April 1st, and will continue until December 31st, 2020. Again, this applies to the paid sick leave and the FMLA expansion. Both apply to any employers who have fewer than 500 employees. So when is paid sick leave required? I have divided this into two broad categories. I've kind of named them the primary category and the second category. And the reason that I've done this into two categories is because depending on where they fall, will determine how much you have to pay in paid sick leave. So the primary category, we've got 3 bullet points. That happens if the employee is under a federal, state, or local quarantine or isolation order. So as of right now, the federal government hasn't issued any kind of nationwide quarantine or isolation order, and neither has the state of Texas, but some localities have. For the most part, it looks like construction has been deemed an essential business, and therefore you don't have to pay paid sick leave if you're an essential business and still able to perform work. But Travis County, the Austin area, where construction has been shut down, then this will kick in for you, and it's effective tomorrow. If your employees can't work because of those local orders and they're still employees, you haven't had layoffs or reductions in force yet, then you will have to pay sick leave under this first bullet point. The second is if an employee is told to self-quarantine, maybe because they've been exposed to someone else, or for whatever reason they are required to self-quarantine, then they fall into this primary category, and you'll have to pay paid sick leave. And then the third bullet point in the primary category is if they're experiencing symptoms of COVID-19, then of course they're not able to come to work and you will have to pay them sick leave. The second category, where they get lower rates of paid sick leave, occur if they are caring for someone who is under a quarantine or isolation order. So that's pretty broad. If they have a family member or someone else that they have to take care of because of those local orders, then they get this lower rate of paid sick leave. Additionally, if they are caring for a child whose school or daycare has been closed, which is happening widely across the state, then they will be entitled to paid sick leave if they need to care for that child. And then the third bullet point is a little bit of a mystery. And it says that the employee gets paid sick leave if they're experiencing a substantially similar condition to COVID-19. Can you guys hear a little bit better now? I'm getting comments that you can't hear well, so I'll try to speak up and let me know if you still can't hear well. So that third bullet point, a substantially similar condition, I don't know what it means. In the bill that was passed, it said that the Department of Labor and the Department of Health and Human Services are supposed to work together to define what this means. And as best I can tell, that has not happened. I have searched high and low for a definition of substantially similar condition, and I can't find that definition. So I don't know if that means you have a cold or seasonal allergies that could possibly be COVID-19, but not quite fitting the symptoms, or if that was kind of a technical cover for the government if there's some mutation or something else that seems like it. But right now it's a really broad category that could require you to pay paid sick leave, even if it's not quite coronavirus related. So if they fall within that primary category, then the amount of sick leave that they're entitled to is the employee's regular rate of pay up to $511 per day and capped at $5,110 total per employee. So if your employee would ordinarily earn less than $511 a day, then you would just pay them their regular earnings. You don't have to pay the $511 a day. If they would ordinarily earn more than $511 a day, then the most amount that you have to pay is $511 a day. And of course, you have to pay them no less than the applicable minimum wage. That would occur regardless of this bill. So again, that's for the primary category, which are things that directly implicate the employee. That's if the employee is under a quarantine or isolation order, or has been told to self-quarantine, or is themselves experiencing the symptoms of COVID-19. The pay rates for that secondary category, excuse me, are lower. So in that case, the employee gets 2/3 of their regular rate of pay. That's going to be capped at $200 per day and $2,000 total per employee. So again, you don't have to pay them $200 a day if 2/3 of their salary would be less than that amount. And again, those secondary categories tend to be things that aren't directly affecting the employee. So the employee is caring for someone else, they're caring for their child before, because their school is closed, and then we have this kind of mystery, substantially similar condition. If your employee has a cold that is symptomatic enough they think they need to stay home, then that would apply. So how much paid sick leave besides the dollar caps? It's 80 hours for full-time employees, and it's an average of 2 weeks' wages for a part-time employee. For part-time employees, you need to take an average over 6 months to determine how much they would be entitled to if their hours vary. Now, here's the real kicker on this ordinance. This is in addition to paid sick leave you already provide or that is required by local law. So if you are already giving your employees PTO, if you give them 2 weeks of PTO, then they get this 2 weeks of mandatory paid sick leave for a coronavirus related issue, the ones that we just talked about. They're entitled to 4 weeks of leave. So this is an additional obligation on top of whatever you're already giving them. Now, required by local law, if you happen to be in a jurisdiction that requires paid sick leave, I assume at this point that would be outside of Texas. Late last night, we got an order on the Dallas sick leave ordinance. It has been ruled unenforceable and is not in effect. So any of you that have been holding your breath, waiting to know what's happening in Dallas, the order finally came down. It will not be enforced. It will not be effective. So you will not have to provide paid sick leave. Those of you in the Austin and San Antonio areas, both of those paid sick leave ordinances are still in the court system. The San Antonio court decided to wait until the Texas Supreme Court rules on the Austin ordinances. So right now, I am not aware of any local ordinances in Texas that require you to pay sick leave. But if it's something that you're already offering, this new federal sick leave will be required on top of what you are already offering. And who gets the federal paid sick leave? All current employees, full-time, part-time, and there is no waiting period. So if they started working for you today, then tomorrow they would be entitled to paid sick leave. Now, moving on to the FMLA expansion. Again, this applies to anyone with fewer than 500 employees. So that's going to be a difference for some of you because typically FMLA applies to employers who have more than 50 employees. Now, if you're in that 1 to 50 range, the FMLA is going to apply to you. The expansion part of the FMLA will apply to you where it hasn't before. If you have more than 500 employees and have to otherwise comply with FMLA, this expansion does not apply to you if you're a larger employer. But the scope of the FMLA expansion is much more limited than the paid sick leave expansion. So the FMLA expansion applies only to an employee who cannot work in order to care for a child under 18 years of age because school or daycare is closed due to a public health emergency. So this goes into effect only to care for children when their school is closed related to the COVID-19. It doesn't apply because of illness. It doesn't apply to care for other people. It only applies to care for children when school is closed, not to exposure or anything like that. Child is, again, any child that you have legal responsibility for or adult children with disabilities. So who's entitled to receive the FMLA leave? That will be an employee who has worked for you for at least 30 days. So there is a waiting period for the FMLA leave. That's a difference between the paid sick leave and the FMLA statute. There is a rehire provision. This was added by the CARES Act that was put in place last week, the big stimulus bill. So if you are rehiring an employee who was laid off before March 1st of this year, and they are rehired, if they worked at least 30 of the 60 days before they were laid off, then there's not a waiting period for them to receive the FMLA leave. So how much FMLA leave do you need to provide? Well, first of all, you don't get FMLA leave for the first 10 days that the employee takes FMLA leave. However, they could take their paid sick leave for the first 10 days, or they could use PTO to cover the first 10 days. And then the FMLA leave would pick up after that. So the two parts of this bill are intended to work together. You get your paid sick leave for the first 10 days, and then you can get your FMLA leave, but again, only for caring for children when their school is closed. After 10 days, the employee is entitled to receive 2/3 of their regular rate of pay, up to $200 a day. This can continue for a total of up to 12 weeks, and there's a $10,000 cap on benefits that you pay under the FMLA leave. Other FMLA regulations apply regarding to notice and how the FMLA leave gets triggered. You're allowed to ask them to give you reasonable notice of the FMLA leave. So you need to have some familiarity with that, but I'm not going into a deep dive on FMLA today. When the FMLA leave ends, you have to restore that employee to their prior position. That's consistent with FMLA law before. However, there is an exception if you have 25 or fewer employees. If you have less than 25 employees and the position no longer exists because of changed operating conditions related to the current pandemic, and you make reasonable efforts to restore that employee to an equivalent position, and that you have to try to contact that employee for up to 1 year after the time that they're not restored to their position. So up until the time that their leave ends and they're not able to return to work. So that's a pretty heavy burden that you will have to comply with to continue to try to contact that employee for up to a year if you fall within this exception. So who can get an exemption to the paid sick leave or FMLA? If you have fewer than 50 employees, you have to have one of the officers of your business determine one of the following. And there are a lot of words on this screen. I know this one's pretty dense. So if an officer of your business determines that the leave payments would result in financial obligations exceeding revenues and cause the business to cease operating. So if you're required to pay sick leave and it's going to run you out of business, then you could be exempt from having to provide either paid sick leave or FMLA leave. The next option, again, you have to have an officer determine that in absence of one or more employees who are requesting leave would entail substantial risk to the financial health or operational capabilities due to those employees' specialized skill, knowledge of the business, or responsibilities. So if this is a key employee and you simply cannot survive without replacing that employee because of their skills, a highly skilled position, then you may be able to claim an exemption. And then the last is if there are an insufficient number of workers willing, able, and qualified to work when needed for the business to operate at minimal capacity. So if you just can't get enough people to do the job, then you can qualify for an exemption. Okay, a few additional requirements that are included in the Act. First of all, you cannot require an employee to find shift coverage in order to use their leave. If they need to use the leave, they can take it and you can't impose additional obligations on them. The other is that there is a mandatory notice that you have to post for all of your employees. I've kind of pasted it into the presentation. This is much too small to be able to read, but it gives you an idea of what it looks like. It's actually a one-page poster that you have to post. Because the government recognizes that many employees aren't in the office right now and you may not be able to post it where your other postings are, you can also email it, mail it, or post a notice on your website for those employees who are remote or teleworking. For your employees who are on the job, I would suggest talking about it at one of your toolbox talks. It's also available in Spanish for your Spanish-speaking employees. Okay, and then there is an anti-retaliation provision included in these bills, both the FMLA and the paid sick leave bill. So you can't terminate, discipline, or discriminate against an employee who uses the paid sick leave or who files a complaint if they're not allowed to use it or about how they're using it. The consequences of not allowing employees to use their paid sick leave or FMLA leave are an FLSA violation, that's the Federal Labor Standards Act. That includes fines, lost wages, liquidated damages, punitive damages. In some circumstances, criminal penalties could also be possible. So you need to be careful with retaliation. And so if you end up having to do layoffs or reductions in workforce after these acts go into effect tomorrow, you need to take care with how you're documenting them and how you're handling them. You need an even-handed way to implement your layoffs and your reductions in workforce so that you are clear that you're not reducing people who are using paid sick leave or who are requesting FMLA leave, and also keep in mind the other discrimination statutes. So you want to do it in a way where you're not triggering any age, race, or gender discrimination either if you're doing reductions in workforce. I had a slide about Dallas paid sick leave, but again, it's been revoked and deemed unenforceable. So that is not an issue. I was very concerned about how that was going to work with the federal sick leave laws before that. So it's been kind of doom and gloom up until now. We do have some good news in here. First of all, there will be payroll tax credits, up to 100% tax credit for qualified sick leave and for the FMLA leave. These payroll tax credits, though, are only for the leave that is provided for in this act, so the things we've talked about today. You don't get payroll tax credits for the PTO that you're already required to provide, or if you happen to be in a jurisdiction where paid sick leave is required, only tax credits for the leave under this act. I suggest talking to your financial advisors and your tax folks about the tax credits and some of these other issues. They will be far more knowledgeable than I am about how those are going to apply. Other good news is what they are calling the Paycheck Protection Program, and this allows certain businesses to receive federally backed loans to cover payroll, paid sick leave, insurance premiums, rent, utilities, mortgage payments, etc. These are generally available to employers with fewer than 500 employees. And if you retain your full staff and payroll, all of your eligible expenses for up to 8 weeks will be 100% forgiven. These loans have to be processed by June 30th. What I'm hearing is sooner rather than later, because banks are expecting to get bogged down with processing these, and there is a limited pool of funds. So if this is something that you're interested in, check with your bank, check with your financial advisors. This may be a way to help you float along until things pick back up again. Another bit of good news buried in the new CARES Act is if you are working on a federal project, there is a provision in there that says that federal contractors may be reimbursed any paid leave that they provide to keep their employees and subcontractors in a ready state if they're subject to a shutdown. There's not a lot more explanation on this. I believe it's limited to federal agencies who receive some of the stimulus funds, but if you're on a federal project that gets shut down, certainly ask about this and see if you can trigger this. I see somebody said they couldn't hear what I said about Dallas. The Dallas sick leave bill was determined to be unenforceable last night. So here are links to additional resources. The Department of Labor website has a lot of good information. So they have the poster that I showed you is available on the DOL fact sheet. They also have, or on the DOL website, they also have fact sheets available. They have a long list of Q&As about how they're interpreting different parts of these acts and how they affect you. So they are a great resource if you have questions about these laws. The CDC also has some good information in providing guidance for business. It has information about hygienic practices, and it also has information about how to get to some of the loans and some of the other resources. And then the information specifically about the small business loan is available on the coronavirus.gov website. So you can get to all of that information, but the one that I found most helpful was the DOL website. It really had some good information there. So I will leave this up for a minute so you guys can see it while I look at some of these questions. I've got several people asking if the presentation will be available. Yes, TCA will have a link to it up on their website. It's not up there yet because I was still fiddling with it this morning because of the changes on the Dallas law. The required poster is on the Department of Labor website. Yes, the expanded FMLA goes into effect on April 1st, 2020. Someone's asking if they terminate today, will they be covered under the anti-retaliation provision? The answer is no. They have to be an employee on April 1st. So if you terminate today, they won't fall within the anti-retaliation provision for the paid sick leave. Again, be careful with how you're handling reductions in force or termination to make sure you're not inadvertently triggering any other anti-discrimination statutes, because we certainly don't want discrimination suits for other reasons happening in the middle of this. I have a question. If you're deemed exempt from paid sick leave, do you still have to post the poster? I think that's a tricky question. There's not clear guidance in the materials that I've read, and basically you'll have to apply for an exemption, so you're not really going to know immediately if you're exempt or not. You're kind of hoping that you're determined to be exempt and you're not going to be subject to any of these issues. I think that's going to have to be a business decision, and it's going to have to be decided on a case-by-case basis. I would take care with not following the statutes, but of course, if you are posting that, then your employees are going to expect it. So that's a question that I don't have a good answer to. I had a question on the Austin shutdown. My understanding is that both Travis County and the city of Austin have excluded construction as essential work, so that construction is shut down. I believe that's already happened, and I don't know for sure when that went into effect. So I would take a look at the city of Austin order and the Travis County order to see when those happened. Okay, someone else has said they are in Travis County and had a temporary layoff as of March 27th. Should they be on paid leave as well? You know, you can go either way with that. If they're in fact laid off, then you don't have to pay them leave and they can collect unemployment benefits. And there are some pretty generous unemployment benefits that are available. So if they're in fact laid off, you don't have to pay them paid sick leave. You get one or the other. You either get unemployment because you're no longer an employee, or you get paid sick leave because you are an employee. So that's again going to be a business decision for all of you, whether you want to do layoffs or provide the paid sick leave. But again, be careful about handling that if you're going to do layoffs after April 1st, so that you don't trigger the anti-retaliation statutes. Someone's asking to go back to less than 50 employees. That is the exemption. Okay, so here's the slide on the exemptions. I will leave this one up for a minute so that you can review it. But basically you determine that if you have to make the leave payments, it will force you to go out of business, or the employees that would be entitled to it are essential to your business, or you just can't get enough workers to do the work and pay the paid sick leave. Someone's asking if the Dallas paid sick leave I addressed is part of the Families First Act. No, Dallas had passed an ordinance that started August 1st. It was technically in effect, but not going to be enforced until April 1st. And so we've all been waiting on pins and needles to see if a court would shut it down. And that happened last night. So there is no Dallas paid sick leave ordinance, only the federal ordinances. Someone asked if these apply to all small businesses or specifically construction. These are not specific to construction. They apply to all small businesses. Someone asked if the mandatory sick pay is included for employers over 500 employees. The answer is no. Someone asked, are employers required to apply our sick leave first or the federally mandated sick leave first? I haven't seen an answer to that. So I don't know. I know they're entitled to both, but I don't know what order they have to be applied in. I can see where you may want to apply the federal first if it's at a lower rate than your other PTO. But I have not seen direction on that. You may take a look at the DOL Q&As to see if they clear that up, but I don't recall seeing an answer to that question. Someone's asking about the loans and if they have already done layoffs, if they can still qualify. I don't know the answer to that. I suggest talking to your financial advisors on that. I've got someone asking if the tax credits are available to employers with over 500 who give paid sick leave voluntarily. The answer, as I understand it, is no. But again, on tax questions, I suggest you talk to your financial advisors. I am not qualified to provide tax advice. Okay, so someone's asking about the employee that's under a federal, state, or local quarantine, and how is this defined? Would a city or a county shelter in place take precedence? I spoke about this for a minute. It's really not defined, and so that's one of the difficulties of this act, is that we see differences in how the state or really how the counties and the cities are handling these ordinances differently. I would comply with the most restrictive, but we see that being challenged. There is a hearing set today where the city of McKinney is being challenged because their restrictions are more strict than the Collin County restrictions for those outside DFW Metroplex. McKinney is within Collin County, so I think we'll get a little bit of guidance depending on how that comes out. But there are some differences in the municipalities versus the counties on whether or not you're subject to a shelter-in-place order that's going to make this challenging to navigate. Again, lots of questions about whether you have to provide your PTO in addition to this mandated sick leave, and the answer is yes. If you provide PTO, you have to give them that PTO plus the federally mandated paid sick leave, but I don't know what order those have to be applied in. The link to the slides has not been posted yet, but it'll be available on the TCA website. I've got more questions about the loans. If you fired an employee for cause, would you be able to qualify for the loans? I don't know. Talk to your financial advisors about the loans and the tax implications. A question about jobs that require scale wages, such as school jobs, are they considered government contracts? That was specific to federal government contracts. So a state public school job would not fall under that provision. So I have a question about workers in Harris County that are classified as essential. I think in most of the state, except for the Austin area, construction has been classified as essential. So if you're essential, you're not falling within the isolation orders, and therefore, unless it's one of the other reasons, such as the employee is actually showing symptoms or has been exposed, then you don't have to provide the mandatory sick leave under that first bullet point regarding isolation orders. I have a question that asks, how many times is the paid sick leave required? Only a total of 10 days, 2 weeks pay. So that 80 hours of paid sick leave, and that's it. You don't have to do it multiple times. If it extends on, you're not required more than the 2 weeks total, even if there are multiple instances. I've got a question about a former employee finding work elsewhere. Do you have to pay their leave? Again, the paid leave is only for current employees. If they have been laid off, then they qualify for unemployment, and those unemployment statutes would kick in. A question about where to apply for the exemption. Take a look at the DOL website. That gives you information about the exemptions. I have a question. If employees were asked to stay home prior to April 1st, does the sick leave apply? The sick leave applies beginning on April 1st. So it's not retroactive. You don't have to pay them for today or yesterday or whatever that day started on, but you do have to pay them starting April 1st for 2 weeks or whenever the need for the sick leave ends. So if the isolation order ends on April 5th, then the requirement to pay them sick leave would end at that time as well. I don't think that's a realistic expectation, but that's how the law will work. Okay, somebody asked me to go back to the first slides. Effective beginning tomorrow. You didn't miss too much in the first 2 or 3 slides. Employers fewer than 500. Confirm local quarantine is the same as shelter in place. Yes, that's what it means. So the city of Austin shelter in place, if it's considering construction to be non-essential, then you would be required under this ordinance or this act. I have a question. If you offer 5 days of personal days, are they counted as sick days? That's going to depend on how it's written in your handbook and if you can require the employee to use those as sick days. And show the mandatory sick leave slides again. Okay, so that's when it's required. Again, that depends on whether you are, the primary and secondary categories affect how much you have to pay. Someone's asking about the employee is told to self-quarantine. Where does that come from? There's not a specific answer on that. I think that can either come from a medical professional, but I think it can also come from the local orders. So if we have orders in place saying if you have been exposed to someone or if you have traveled outside of the state, then you're required to self-quarantine. That can come into play there as well. I have a question about if you're providing additional pay to help out employees, will paid leave need to include this amount? The paid leave has to include the regular amount that the employee receives. So if an employee typically receives hazard pay or something like that, that would need to be added in. If you've just started providing additional pay, I I think that's in a gray area. Um, what you might want to do is take that 6-month average to figure out. That's guidance for part-time employees, um, but the additional pay isn't their regular pay, so I think that's a little bit of a fuzzy area there. So I have a question. Since construction is currently considered an essential business and our company can stay open, does the paid leave apply if an employee chooses to stay home and not come to work? The answer is no. It, it applies only if they fall within one of these categories. The question about if they had 50 employees during March but are now under 50, is it considered fewer than 50? I don't know the answer to that. I don't recall if there was, I do think there was a calculation in the statute for how to calculate the number of employees, and I don't recall how that calculation is. Again, I would refer to the DOL website. Their Q&A section is really helpful. Um, you can also look at the act, or let me know if we need to look at that more closely. I'll make a note to look at that calculation. And I had a question that came in earlier today about employees using paid sick leave and employment and unemployment together and earning more than they would if they were coming to the job site. Um, that is not a possibility because you can only use paid sick leave if you're still an employee. You can only get unemployment if you're not an employee. So you don't get both at the same time. And again, the paid sick leave is only under the categories that are on the screen right now. So you're really not going to get both. I have a question about whether the new act triggers FMLA requirements to apply to businesses with less than 50, or all the FMLA requirements for businesses with less than 50 employees, and if so, for how long? It doesn't apply all FMLA requirements, only for the limited scope under this act, which is if you are there to care for a child because their school is closed. That's the only thing that applies to smaller businesses. I had a question about the payroll tax reimbursement. Um, so it's not full payroll reimbursement, it's just payroll taxes, and it's only for paid sick leave or FMLA wages. It's not for all wages, and it's not for paid sick leave that you provide as an employer. I have a question about, can you require a doctor's note? Yes, you can require documentation. I have a question about whether the paid sick leave can be used intermittently. That is up to the employer on whether they want that to allowed to be used. That's really for teleworking employees, because if you have someone that's falling under a quarantine order because they've been exposed, or someone who's experiencing symptoms, they really need to use that whole block. But if you have someone who's teleworking and they need to take a day here and there to care for a child or something to that effect, yes, they can use it intermittently. I have a question about on the exemption, you have 100 employees, but an insufficient number willing to work. No, you have to have fewer than 50 employees. I have a question, unemployment overrides sick leave. If they claim unemployment, we're no longer to pay sick leave. If they claim unemployment, again, they're not employed, paid sick leave, they have to still be employed. So it's one or the other. The payroll tax reimbursement begins April 1st as well. So even if they have been taking sick leave before April 1st, you don't get the reimbursements. They start on April 1st. If telework's available and the employer refuses, do you have to pay sick leave through this mandate? No. If they are able to perform telework, then you do not have to pay them sick leave. If an employee decides themselves to self-quarantine but do not have children that they're caring for, do they qualify for sick leave? No, not unless they fall under one of these categories, such as they're under an order, told to self-quarantine, cannot telework. Then, of course, the problem is that you have this substantially similar condition catch-all. If they tell you that's what's going on, you may have to provide them with sick leave. A question about what kind of proof do you ask the employee to provide to stay home and care for a child? What if you know they have someone at home to take care of the child? I think that's another one of those gray areas. I don't know that you get out of paying sick leave just because you know someone else is there. If you have a local order in place saying that your schools are closed, you are probably on the hook for paying sick leave. So question, if they're out once to take care of themselves and a second time to take care of a family member, do they get the paid sick leave twice? No, only once. However, well, it could be when the FMLA kicks in, but again, that's only if they're caring for a child who is not at school. The other thing on the FMLA exemption, they get a total of 12 weeks, but if you've got somebody who has already used some weeks of their FMLA because they had a child or they've had an illness early in the year, that 12 weeks of FMLA is for the total year. So if someone's already used 4 weeks of FMLA, now they want to use FMLA to care for their child out of school, they've only got 8 weeks left. What kind of proof do you need of symptoms? There's not guidance of that. You can ask for documentation that they've sought medical treatments. Are both spouses entitled to mandatory sick leave if they both choose to stay home to care for a child whose daycare is closed? I don't know that we've got a clear answer to that. I do know that the FMLA limit for spouses, I believe, is 10 weeks. That's in place, but whether they get paid sick leave, I'm not sure on. Someone asked about the poster on the DOL website versus what's in my presentation. Use the one on the DOL website. I think it got formatted weird in my slide. Okay, someone's asking about the pay calculation. So if it's a primary category, which means that employee is directly affected, they're the one experiencing symptoms or is under an order to quarantine, they get their regular rate of pay up to $511 a day, a total of $5,110, which is 10 days at that $511 rate. So, but it's their regular pay. If it's less than that, then they will get paid less than $511 a day. The cap really applies to your higher earning employees. And it's in the second category because they're caring for someone else, or the mystery substantially similar conditions, symptoms, then they get 2/3 of their regular rate of pay, and that's capped at $200 a day, $2,000 per employee for paid sick leave, $10,000 for FMLA leave. I see lots of questions about having a child at home to care for. You can ask for, I guess, documentation of their child. The orders closing schools are available, so check that against orders. I think most schools in Texas are closed right now, at least in the more urban areas. Okay, if an employee is told he is still an employee but has to stay home until quarantine is lifted, can he be paid an employer, get reimbursed, or can he file for unemployment? If he's an employee, he can't get unemployment. And if he's told to stay home because of a quarantine, he would be entitled to the paid sick leave. Remember, the reimbursement is only for payroll taxes. It's not for all of their wages. I have a question about the differences between the last bullets in the primary and secondary category, which is, let's see, a great question. And I don't know. We touched on this a little bit. The Act directs the Department of Health and the Department of Labor to come up with a definition of substantially similar condition. They haven't done so yet, at least as much as I can find. So I'm not really sure on what those definitions are, and I think that's a real muddy gray area to try to navigate to figure out when they fall into each of these categories. And again, the two categories, the differences are the amounts you have to pay, either the $511 a day cap or the $200 a day cap. I've got a question. If employees are refusing to work, should you have them go on regular FML leave so you have an end date? Regular FMLA leave is for employers with more than 50 employees. You can require them to take FML leave. Just make sure you're dotting all your I's and crossing your T's with the notice requirements and the documentation that's required for FMLA leave. You can do that, or you can terminate so they can collect unemployment benefits. There's not a lot of guidance on the exemptions. I'm seeing a lot of questions about that. There is some guidance on the DOL website, and it basically reiterates what we said here, that an officer has to make the determination. I believe there's a way to apply through the DOL website, but it does say not to send them any documents at this time. However, you need to keep records and documents of how you're making that determination if you think you might qualify for an exemption. Proof because spouse is sick, again, you can ask for documentation, ask for a doctor's note. Lots of questions about the reimbursements. It's payroll tax only. You do not get reimbursed for full wages. I think some of that confusion is coming in on the payroll protection program. That is for a loan. So if you apply for the loan and you retain your staff and your payroll, then you could be eligible to have the loan forgiven up to the amount that you paid, but you have to apply for and get that loan approved. So that's forgiveness of a loan. That's different than the tax reimbursement. So if you think you might qualify for this loan and that would be helpful for you, talk to your banker, talk to your tax advisors or your financial advisors, and also talk to your tax advisors about the payroll tax rebate. So that's a tax credit for the payroll taxes that you are paying for qualified sick leave and FMLA leave. You do not get those wages reimbursed, but they might be forgiven if you take out a loan. I have a question about caring for a child that's not a direct relation, such as a boyfriend or girlfriend. Stepchildren apply, legal wards apply, boyfriend, girlfriend, I think is a little bit of a gray area whether that applies. It's really someone that you're legally responsible for. You're not legally responsible for those children. If someone asks if you have less than 20, are you automatically exempt from FMLA? No, you have to meet those exemption requirements. This limited scope FMLA applies. And again, it's only to care for children whose school have been closed. Someone asked with the $5,110 cap, if the employee makes less than $511 a day, do they have to pay up to the whole $5,110? No. The $500 per day is the cap. It's based on a daily basis. Yes, I have a question about the FMLA cap says $2,000. The FMLA cap is $10,000. Okay. Paid FMLA leave, they get up to $200 a day, up to 12 weeks, a $10,000 cap. Reasonable notice for an employee to take the emergency FMLA. Reasonable is one of those fuzzy notices. It's, if they know in advance they're going to have to take it, they need to let you know in advance. If they don't know until the day that it happens, then that may be what's considered reasonable. Someone's asking about if they apply for the loan and the forgiveness, will that include all payroll or only paid sick leave? That applies to all payroll. Okay, I have a question from somebody saying that they had a employee who had to leave to care for a parent that is not COVID related. Would they be entitled to leave? The answer is no. Has to be related to the coronavirus. And then less than 50 employees have not had FMLA in the past. Must we pay it now? Yes, you are required for the emergency FMLA in the limited scope where someone's caring for a child because their school has been closed. Okay. Moving over to the Q&As, you have to post the poster on the job site. If you have the ability to do so, yes, that's always a challenge on a job site. So talk about it at your toolbox talks, send it out via email, put it on your website, however you can get that information communicated to your employees. Was Dallas sick leave blocked? Yes, it was last night. Asking about the slides for the presentation, they'll be available on the TCA website. Okay, a question, if there's a quarantine, but the construction projects, but there are projects the employee can work on, but they don't want to come to work because they're scared. If the employee's choosing not to work and work is available, they don't qualify. I'm going to scroll to the bottom because these earlier questions I think have been answered. Someone's asking, FMLA is typically unpaid, so is this new order different, requiring employees to be paid for the 12 weeks? Yes, it is different than regular FMLA. We've got this slide up right now. So you do have to pay them up to $10,000 for a total of 12 weeks. Again, that's based on 2/3 of their regular rate up to $200 a day. If their regular 2/3 of their regular rate would be less than that, then they don't have to, then you don't have to pay the full $200 a day. But yes, this does require paid FMLA leave. Okay, I'm getting some comments that you may be getting credits for wages and not just payroll taxes. So again, talk to your financial advisors, talk to your tax folks. They know more about those issues than I do. Okay, I have a question. What's the difference between FMLA and the Families First Coronavirus Response Act? The Families First Act went into effect or was passed on March 28th, and it modifies FMLA. So it creates an emergency expansion of the FMLA law that's currently on the books. So this expansion is included in the Families First Coronavirus Response Act. And then the paid sick leave is included in the Families First Coronavirus Response Act. And so those are what we have talked about today, are the additions that are included in that act. There are also a couple of changes that came out of the CARES Act. That was the big stimulus package that was passed just a couple of days ago. And those modified both the FMLA and the paid sick leave that was just added. Paperwork for the employees to sign up for the new FMLA. There are some notice requirements that are required with FMLA. where the employee has to send out the employer has to send out a notice about how long it's being used and collect some documentation. Again, this isn't a heavy coverage on FMLA requirements, but yes, that is something you will need to look into. If I have 10 employees, do I still fall under this? Yes, there is no minimum number of employees. This affects small employers. Sorry, guys, I'm scrolling through your questions here. We'll have to wrap up pretty quickly. We've gone a little bit over our time. Okay, so I have a question here. If the employee goes to the doctor because they have a fever, but they don't have COVID and are told to stay home from work for a different virus that is not covered under the act. If they're told to stay home from work, I think this is where our substantially similar symptoms comes in. Yeah, I think you would have to pay under the substantially similar symptoms. Okay, I have a question. If they're claiming FMLA, can you require weekly updates? Yes, you can require regular notice about when they will return for both the paid sick leave and the FMLA leave. I have a question on FMLA if they have partial custody rather than full custody. I think if they're saying they're the one caring for the child, then while they're actually caring for that child, they'll be entitled to the FMLA leave. I don't know who has custody will matter there. Okay, I have a question. If an employer has less than 50 employees, starts to pay the sick leave, and then gets overburdened because too many employees get sick, can they then claim the financial hardship? Yes, I think that's when the exemption comes into play. I think the intent of these acts is to try to keep people working and paid as much as possible. Okay, someone's asking about the paid sick leave and FMLA. Is it just wages? What about annuity, medical, and other labor burdens beyond wages? Um, there is talk about healthcare. I'm not sure about all labor burdens. Healthcare is covered for a period of time, and I think it remains in place through the FMLA, but the employee is expected to continue to make their contributions. I'm not sure on the other labor burden items, but I don't think you would be required to continue with those. A question on FMLA, does a child or disabled adult need to be a dependent on the employee's tax return? I don't know the answer to that. I have a question about the loans. Again, I don't have in-depth information on the loans. I suggest you speak to your financial advisors. I have a question. Would a company qualify for the Paycheck Protection Program even if they are deemed essential and still working? I believe so, but again, talk to your financial advisors. I know we're hearing a lot of that, and a lot of the information in these acts is really very tax oriented, which is beyond what I do. But the tax questions and the loan questions, your bankers, your accountants, your financial people will be better able to answer those than I am. One question on the loans. It's asking if it's limited to nonprofits, veterans organizations, tribal concerns, sole proprietorship, self-employed. Is it limited to those? No. It's for employers with less than 500, the SBA loans. Employers with less than 500 employees. There are loans available also for those larger employers. They're not quite as favorable as the small business SBA loans, but they do have, I think it was a capped 2% interest rate and some deferment periods. So if you are not one of the small, less than 500 employees, employers, you might look into those larger business loans as well. I have a question about whether employees that have been around for less than 90 days um, qualify for FMLA. Yes, 30 days is the cap, is the waiting period for FMLA unless it's a rehire. And there is no minimum time period to get the paid sick leave. I have a lot of questions about partial unemployment and the paid sick leave, and I don't have information on how those two work together. So I can try to look into that, but I don't have that information right now. Okay, so here's a question. Can you stop FMLA when schools would normally be closed for summer? That's a great question. The emergency FMLA um, legislation says that it ends when the need for it ends. So if the closings are lifted before the end of the school year, it would be lifted. Um, if it's when schools are closed for summer, I don't know that it would apply. I'd have to look specifically at the text of that legislation, but I believe it says because the school has been ordered to be closed, so it wouldn't necessarily be ordered. So maybe not. That's a great question. I'm going to make a note of it. Because I don't think they would be ordered to be closed at that point. They might, though. There's summer schools and other programs, so it's possible that order could be extended, and then you would be required to extend your FMLA. Okay, I think I have gotten through most of the questions. If I missed your specific question, I apologize. I appreciate you all taking the time to be here. We will get these slides posted up on the TCA website. And here is my contact information if you want to email me. I will try to answer additional questions by email as I'm available, but I appreciate your time today, and we'll continue to see what happens here.